Ms. Baldwin, for what purpose do you seek recognition?
Mr. Chairman, I would like to, I have an amendment at the desk and would like to offer actually 4 amendments en bloc in the interests of moving things forward.
4 amendments. Are all these amendments to this title?
They are all, as I understand, all amendments to this title, and all have been filed the requisite amount of time. May I announce which 4 they are?
Yes, please.
All right. Baldwin 55, Inslee 46, Rush Low Income Energy Efficiency Grant Program, and Schakowsky Office of Consumer Advocacy.
This goes with you too. Oh, each of these is a different amendment.
Is there objection to offering these amendments in block? Hearing none, that will be the order. The clerk will report each of the amendments.
Amendment to the amendment in the nature of a substitute offered by Ms. Baldwin. On page 35.
Without objection, that amendment will be considered as read. What is the next amendment?
Amendment offered by Mr. Inslee of Washington.
Without objection, that amendment will be considered as read.
Amendment offered by Mr. Rush of Illinois.
Without objection, that amendment will be considered as read.
And an amendment to the amendment in nature of substitute offered by Ms. Schakowsky of Illinois.
Without objection, that amendment will be considered as read. Ms. Baldwin, Chair recognizes you for 5 minutes, and you may then yield to the other authors of the.
Mr. Chairman, may we dispense until we get the amendments? There are 4 of them. I just ask
okay.
for a moment, please.
Let's have all the amendments distributed.
Thank you, Mr. Chairman.
They're on the way. Chair recognizes the gentlelady from Michigan.
Wisconsin.
Wisconsin.
Thank you, Mr. Chairman. The amendment that I am offering ensures that solar water heating and solar light pipe technology qualify as energy efficiency technologies when FERC prescribes standards and protocols for defining and measuring electricity savings under the new Combined Efficiency and Renewable Electricity Standard. Solar light pipe technology is energy technology that displaces energy demand in a way that can be accurately verified. The Energy Independence and Security Act describes the energy derived from solar light technology as direct solar renewable energy. These technologies present a relatively new and effective way to provide emissions-free energy. The light pipes, like the ones constructed at Orion Energy Systems in Manitowoc, Wisconsin, use direct solar energy to illuminate the inside of buildings, thus eliminating the need for electrical light fixtures during many daylight hours. This results in maximizing available energy savings and significantly reducing carbon emissions, saving U.S. companies millions of dollars every year. Equally important, the construction and installation of solar light pipe technology would support thousands of good-paying jobs. By including solar light pipe technology and other direct solar renewable energy in the bill, countless companies will be provided an opportunity to utilize this technology. With that, I would yield time to Mr. Inslee to discuss his amendment.
Thank you. We have a small, hopefully non-controversial amendment which would authorize the National Bioenergy Partnership. This is an existing program, but it's never been authorized. These programs essentially are administered by use of the governor's offices, state or nationally. They help the distribution of information both for development of technologies in bioenergy and for marketing. This is a wonderful little program that helps small businesses get up to scale in the development of bioenergy. That includes cellulosic feedstock research and development of low-carbon biofuels. It includes technical assistance for deployment of methane digesters and biogas generators, and sustainability research on woody biomass harvesting and wood pellet fuels. It's a great program. It's limped along. This would authorize it and allow us to get it going on a more full-time and consistent basis. Thank you.
I would now yield time to Mr. Rush to describe his amendment.
Thank you, gentlelady. Mr. Chairman, this program, the Low-Income Community Energy Efficiency Program, is a vital program that authorizes the Secretary of Energy to make grants to private, nonprofit, mission-driven community development organizations. These organizations may include community development corporations and community development financial institutions that will provide financing to businesses and projects to improve energy efficiency. Additionally, this funding will help identify and develop alternative and renewable and distributed energy supplies, provide technical assistance, and promote job and business opportunity for low-income residents and increase energy conservation in low-income rural and urban communities. These grants will also provide capital to minority-owned and women-owned businesses and finance entrepreneurs looking to create new jobs, new technology, and economic development opportunities in communities that are far too often overlooked. Mr. Chairman, this program is vital, and it brings capital to communities that I represent. I yield back.
I would now yield time to Ms. Schakowsky to describe her amendment.
This amendment really is for the little guy. It would establish an Office of Consumer Advocacy within the Federal Energy Regulatory Commission, an office that would represent the interests of America's energy consumers. For too long, no one at the federal level has been watching for abusive rate hikes on consumers, particularly on senior citizens and small businesses. Most states already have established offices of consumer advocacy that stand up for the ratepayer. Consumers have faced higher prices and limited, if any, choices. State consumer advocate offices have worked diligently to protect consumers. However, they have limited resources. In addition, because so much energy activity is interstate in nature and so much of the energy business has moved interstate, the state advocate offices are not sufficient. The office created by my amendment would collect data, investigate services and rates, monitor and review customer complaints, and represent customers before the Commission in other proceedings. Also, it would publicly disseminate information and issue reports and recommendations. In addition, the amendment would establish an advisory committee to that office that would review rates, services, and disputes and make recommendations. The committee would include state utility consumer advocates to ensure that consumers are protected at the state and federal level. The advisory committee would also include a non-governmental consumer advocate. A federal energy consumer advocate would be an independent watchdog over a variety of important issues that come before the FERC and before other agencies. This amendment was drafted in consultation with FERC, so it doesn't duplicate any of its other services, and it will provide essential protection for consumers. I urge adoption of the amendment.
Mr. Chairman, I yield back my remaining time.
Time has expired. Mr. Barton.
Mr. Chairman, at the appropriate time, I'm going to move to divide the question. You've got 4 amendments that have been offered in block. We didn't object to that. But on review of the 4 amendments, the minority is willing to accept the Rush amendment and the Baldwin amendment. And we think that they are either meritorious or at least innocuous, so that we can accept them. But on the Inslee amendment and the Schakowsky amendment, the Inslee amendment is authorization earmarking which I thought members on both sides of the aisle were opposed to, and the Schakowsky amendment is duplicative because 40 states already have consumer advocates, and it is very unclear how adding a national consumer advocate in the office of the Federal Power Commission would do anything but muck up the waters. So
Will the gentleman yield to me?
be happy to yield to
Let me put unanimous consent that the committee consider the Rush and Baldwin amendments in block separately from the Inslee and Schakowsky amendment. And if that's without objection, that'll be the order. And I'd like to now put the question for the Rush and Baldwin amendments. All those in favor of those two amendments say aye.
Aye.
Aye. Opposed, no. The ayes have it, and the amendments, the two amendments are agreed to. Now we have the Inslee and Schakowsky amendment to be considered together. Do you wish to speak against those amendments, or are you ready for the vote?
Well, I have spoken against them.
Okay.
I'll yield back my time, but there may be other speakers who wish to speak against them.
Any further discussion of it? If not, yes.
Mr. Chairman, my comments will be directed initially to the Schakowsky amendment, and I'm trying to get this straight. We're going to set up an office in the FERC that's designed to hear consumer complaints against utilities that have raised rates because of this bill. That's what we're doing. We're setting up a office in the FERC to hear the little guy's complaints about the raised rates by the utilities who are passing on the rate increase because of the cap and tax bill. So we're going to go after the utilities for which we've charged this, and that's what this federal agency, we've had a lot of talk about the public utility commissions in the states, which are supposed to be doing that, and all throughout the day you all said, don't worry, we've got the Public Utility Commission for the states there protecting the little guy, but now we have to have a federal office to do the same thing. And in reading the text of this, bring complaints on behalf, represent and appeal on behalf of energy customers on matters concerning rates or service of public utilities and natural gas companies under the jurisdiction of the commission. So we agree rates are going to go up. We agree there's going to be complaints. Now we're going to have a federal commission to go after the utilities who've raised rates because of this bill. I oppose this amendment. I yield back.
Gentleman yields back his time. Ms. Schakowsky?
Well, I'd like to just let the gentleman know what the Federal Energy Regulatory Commission does, among other things. Approves the siting and abandonment of interstate natural gas pipelines and storage facilities, ensures the safe operation and reliability of proposed and operating LNG terminals, ensures the reliability of high-voltage interstate transmission systems, monitors and investigates energy markets, uses civil penalties and other means against energy organizations and individuals who violate FERC rules and energy markets. For example, the FERC was involved in the California electricity crisis, investigating allegations of electricity market manipulation by Enron and other energy companies. So there's a wide variety of activities where those of you who have been wanting to look out for the little guy, we set up really a consumer advocacy office within the Federal Energy Regulatory Commission on all these matters, a place for the consumer to go when they have a problem with things that are under the jurisdiction of FERC, which are beyond rates, but it could be about abusive rate hikes on consumers. And we provide a place where we have special advocacy for the little guy. And I would say that it's completely in line with the arguments that you're making and something that everyone ought to support. Thank you.
Ken, yield to me, will you?
And I would like to yield then to Mr. Inslee.
I want to briefly respond to Mr. Barton's comment. He suggested that the biofuels partnership amendment I've offered is somehow an earmark. I can't understand that argument. This is about as far as an earmark as you can get. This program exists in all 50 states. It's administered by the largely by the Governors Association. It will not go to any particular district. If I was going to do an earmark, it would go mostly to Mr. Doyle's district, so I could perhaps get in the baseball game this year because he's a coach. So I just want to assure my comrades in arms that this is not an earmark, it's an authorization. We should pass it.
Gentleman yield.
Certainly.
What is the Pacific Regional Biomass Energy Partnership led by the Washington State University Energy Program, if that's not an authorization earmark?
Well, that program basically serves essentially the whole country, and I will take a long time to explain this. Well, no, it is not, because it's serving the whole country.
Washington State University Energy Program is not an authorization. That's who's going to lead it. That's
if you excuse me, let me answer your question. This bill, there are 5 centers of partnerships. One is called CONEG. It serves Connecticut, Delaware, Maine, Maryland, Massachusetts, New Hampshire, New Jersey, New York, Pennsylvania, Rhode Island, and Vermont. The second is the Council of Great Lakes Governors. It serves Illinois, Indiana, Iowa, Michigan, Minnesota, Ohio, and Wisconsin. The third is the Southern States Energy Board that serves Alabama, Arkansas, District of Columbia, Florida, Georgia. I won't list the rest of them. The fourth is the Western Governors Association. It services Arizona, California, Colorado, Kansas, Nebraska, Nevada, New Mexico, North Dakota, Oklahoma, South Dakota, Texas, Utah, and Wyoming. And the fifth is the Pacific Regional Biomass Energy Partnership, led by the WSU, Washington State University Cougars Energy Program. It serves Alaska, Hawaii, Idaho, Oregon, Montana, and Washington. If this isn't earmarked, every single thing we've authorized, including the DOD budget that serves all 50 states, is an earmark. Come up with some good argument here.
That is an argument. Then you should remove the names and set up a regional national bioenergy partnership and dictate the 5 regions of the country. You're earmarking.
Gentlemen, the time is in the hands of Ms. Schakowsky. Do you wish to yield or yield back your time? I know Mr. Blunt is seeking recognition. Without objection, the time will be yielded back, and Mr. Blunt is recognized.
Mr. Chairman, we've heard all day how we don't need to be worried about unemployment. We don't need to be worried about utility rates. We don't need to be worried about residential utility rates. We don't need to be worried about gas. And now we find we've got to have a whole new regimen to be concerned about all of those things. But I'll yield the time to Mr. Barton.
I just want to point out there may be one positive reason to put the Schakowsky consumer advocate at the FERC. The current chairman that's been appointed by President Obama has publicly stated that he opposes any new nuclear power, any new coal-fired power generation, and that in his opinion we can meet the electricity needs of America purely by conservation. So perhaps we need a consumer advocate in the FERC to protect the country against the chairman of the FERC. That might be one reason to support this amendment.
Gentlemen, yield back the time. Why don't you yield to Mr. Shadigan?
Oh, I would. Shadigan? I yield. Well, I have questions for counsel. Apparently there's some confusion about the meaning of the language on pages 1, line 17 through 19, on page 2, line 1 through 3. I'd like to ask counsel. It says that this office may bring complaints on behalf of, represent, and appeal on behalf of energy customers on matters concerning rates or service of public utilities and natural gas companies under the jurisdiction of the Commission. My question of counsel is, does this mean that this office could bring a complaint on behalf of a customer who gets electricity from, for example, the Western Power Authority, which has generation capacity in the western United States and which sells electricity throughout the western United States and transmits that over power lines in the western United States and I believe is under the jurisdiction of what is referred to here as the Commission, meaning FERC. Is that correct?
I apologize. I was finding a copy of the amendment as you were citing the page and line numbers.
Page 1, lines 17 through 19. Page 2, lines 1 through 3. Who are the consumers on behalf of whom the office may bring these complaints, and against whom may they be brought?
This intended office would represent the consumers that the Natural Gas Act, the Federal Power Act, was enacted to protect. As both those statutes have a fundamental purpose of consumer protection, those are the consumers who are served by the regulated entities regulated by the Federal Energy Regulatory Commission under those statutes.
And if they are already protected by the Arizona Corporation Commission, or if they are already protected by the Residential Utility Consumers Organization in the state of Arizona, is there anything in this act which stops them from bringing a duplicate consumer protection action against those entities?
This entity would only work in the proceedings conducted at FERC for FERC-regulated entities, and FERC does not have duplicate proceedings with the Arizona Public Service Commission or other state commissions regulating the state-regulated utilities.
Okay, and then, so then who are the consumers that this is referring to, or the customers? Energy customers.
It might well be Arizona Public Service Company paying a wholesale rate for power that is under a FERC-regulated wholesale tariff.
So it would allow Arizona Public Service Company, a regulated utility, to have a matter brought by this office on its behalf against WAPA.
In general, Arizona Public Service represents itself and doesn't need this office, but does it?
Well, I guess I'm trying to figure out who does need this office. I appreciate that point. Can you give me an example of a consumer, a small business, or a residence that would be able to take advantage of this language?
Certainly that would be up to this office to determine what they perceive to be the consumer interest in any particular proceeding, and to the extent they identified that interest, to represent it.
Well, it says, on behalf of energy customers on matters concerning rates or service of public utilities and national gas companies under the jurisdiction of the Commission. Well, I guess my question to you is, are any small businesses or residences customers of public utilities and natural gas companies under the jurisdiction of the Commission? Or are only utilities and gas pipelines customers of those utilities under the jurisdiction of the Commission?
Will the gentleman yield on that
I'd like to get counsel's answer, and then I'd be happy to yield.
Okay.
The consumer's interests are represented at the Commission in a number of ways, and a number of parties participate in the Commission's proceedings as direct customers, as consumer interest groups, and this office would be intended, as I understand the amendment, to identify what is perceived to be the consumer's interest in the same way that state consumer advocates' offices attempt to do so and represent those interests in the proceedings of their commissions.
I appreciate what you understand their intent is. I would be happy to yield to the chairman. I would still like to hear the name of a small business or of a residential customer who could be represented.
The FERC handles the wholesale power, and in California, businesses and consumers were gouged by Enron Corporation, and FERC took no action. Had this office been in place, the small businesses and the consumers in California could have gone to this office to seek some redress because FERC was not responding.
And those individuals are customers of a utility under the jurisdiction of the Commission? As this language?
Yes.
Thank you.
My understanding.
And yield back.
Are we ready now for the vote on the
I have
Inslee and Schakowsky amendment? Mr. Terry.
I have a question on the Schakowsky amendment. Does the customer consumer advocate have what would their real powers do in representing them? Would they be able to help the consumer with lawsuits?
Why do you say that's not true?
Would they be able to help overturn a FERC decision? I'm going to ask counsel.
Could the gentleman yield for just a minute? And I
Sure.
think I can answer and give you some examples, for example, that might answer your question. The FERC has collected over $6.3 billion from California electric market participants by facilitating settlements. FERC is also working with Canadian energy officials to facilitate processing of a proposed Alaska natural gas pipeline, which would bring natural gas from Alaska's North Slope to the lower 48. As I mentioned earlier, was involved in the California electricity crisis, investigating allegations. So this would be an example of an investigation of electricity market manipulation by Enron and other energy consumers. So they were able to take their case to the FERC that then did the investigation. Just examples.
But they wouldn't, the advocate wouldn't have the power to develop a lawsuit on behalf of the consumer against Enron?
All of these activities, as I understand it, take place in front of the Federal Energy Regulatory Commission.
How about decisions by FERC? For example, if we pass an amendment here giving FERC siting power on transmission lines, can a consumer that ostensibly would be impacted hire or go to the consumer advocate to get FERC to overturn that, or find out a way to sue FERC to overturn that? Go ahead, Janice or counsel?
Consumer advocacy offices, as they operate in the states where they operate, attempt to identify the general consumer interest.
How would it operate here under the wording of this amendment?
Well, they would essentially be in the place of another party before the Commission in its proceedings, representing the general consumer interest rather than the specific interest of any particular party that is represented in those proceedings.
So, for example, with LNG siting, where FERC would have permitting priority, the community was heard once, FERC decided differently. Can the community or its constituents then hire the advocate to then advocate for them against FERC, even though they already had a shot for that at a proceeding, prior proceeding?
Well, they would be subject to the same procedural rules as any other party. They would not get two bites at any particular decision, and they would not represent individual consumers. They would not be hired by consumers. They would be public servants working in the Commission to identify the general consumer interest and assure that it was represented to the Commission for the Commission's decision making.
Would the gentleman yield?
I would yield to
under
the gentleman.
current law in electricity. FERC has jurisdiction over wholesale transactions in interstate commerce. Wholesale transactions in interstate commerce for electricity. You're going to set up a consumer advocate's office that would be a consumer advocate for large power companies and states that engage in wholesale electricity transactions across state lines. Retail rates and retail transactions are regulated, if at all, at the state level by the state PUC Commission.
Will the gentleman yield?
Claim back my time, yield to the gentleman from Kentucky.
Also on page 2, when it talks about the responsibilities of this advocate representing the consumer at hearings of the Commission in judicial proceedings, but the way I read this, they also would have the authority to represent consumers at hearings or proceedings of other federal regulatory agencies and commissions, which I would interpret to mean any federal agency in the federal government. How would you interpret that? On page 2 on line 9.
That's what the language says.
So this would not be applicable only to FERC. This would be applicable to any federal agency or commission.
Well, I would interpret that as meaning that to the extent a FERC proceeding or a FERC issue were picked up at another federal agency, such as, for example, if a gas market issue became an issue at the consumer.
Well, you know, once again, it would get down to judicial interpretation because the language clearly states at hearings or proceedings of other federal regulatory agencies and commissions.
The time has expired. Is there further debate? Who seeks recognition?
Chairman?
Yes, Mr. Boyer.
I move to strike the last word. And I would ask my friend from Washington a question, because I'm trying to, as I read your amendment, I mean, I read this, and this is something that I think is good. If we want to really engage and support the private sector for institutional physical infrastructure necessary to promote development of sustainable biomass fuels, bioenergy technologies, I don't have problems with that at all, Jay. I just don't understand how you could have voted against the Walden amendment and then offer this amendment. So help me understand. I'm out in the Midwest. We got corn. I don't have forest. So help me understand how you could, when Mr. Walden sought to help me reconcile that. How do you vote against Walden and then offer this amendment?
Well, there are certain questions you probably wish you hadn't asked, and I think if you give me your last 4 minutes, you'll probably decide you wouldn't want to ask that question. But the answer is that my friends across the aisle seem so enamored with benchmarks now. But I don't remember them saying that you were going to put benchmarks.
Wait a second.
Now you asked me a question. If you'd like me to answer it, I will answer it. Would you like me to answer the question?
I don't think it has anything to do with benchmarks.
Well, you asked me a question, friend, and if you'd like me to answer it, I will. And if you want to go home and take a vote on this, I'll do that. Which would you prefer? Either one's fine.
Well, then I'll reclaim my time.
Fine with me.
I ask you a very simple question, and you want to talk about benchmarks. I look at your amendment and go, Jay, your amendment makes sense. What I can't reconcile is, how do you vote against Walden yet offer this amendment? So now I'll ask that specific question.
If you'll ask me and give me your remaining 3 minutes, I'll answer your question. And the reason is your benchmarks are so outside of the realm the way you make legislation. Let me give you an example. When we had the Enron crisis, and we went on a bipartisan basis to the Bush administration asking them to solve this problem for the little guy, whose rates went up 1,000% in the West Coast. And we went to Vice President Dick Cheney, and we pleaded with him to do something about it. Mr. Vice President, please set a benchmark that if the rates remain so outrageous that you'll do something about it. We didn't get any benchmarks from the Republican administration to do anything about the Enron situation. When we had the Bush tax cuts...
All right, I reclaim my time. I don't know what the hell Bush tax cuts and Enron have to do with this specific...
What it has to do with is when you adopt legislation, you don't try to predict the entire future. If you want benchmarks, I suppose we could put benchmarks in that if this does what we think it's going to do, which is to create twice as many jobs as we even think it will. I'm much more optimistic than many of my colleagues. Should we put a benchmark in that if it creates more jobs that will adopt a tougher cap? No, because it's just too difficult to get the crystal ball out. All I know is we're going to have Congresses in the future. If this thing goes sideways, future Congresses can deal with it. If it's better, they can make it even tougher.
Right, let me reclaim my time. No, wait a second. This is my time. I still don't get it. I asked a very simple question, how you reconcile voting against Walden and offer this amendment. I think this is a good amendment. I just can't, please close the door. Please close the door. I can't figure out how you vote against Walden and then offer this amendment. I look at this and say, okay, my wife and I not long ago went from Denver and drove up towards Breckenridge onto, Vail. And I see, as I come over the first ridge, I see forest as far as the eye can see, and it's dead. It's dead. At some point, if that catches fire, Breckenridge is going to be gone. And I look at that and say, why can't we go in and go get that wood? And when I look at as whoever drafted this, and I listened to Mr. Stupak talking about this negotiation, and, Mr. Walden here came and he tried to provide a definition with regard to what is a mature forest stand. And, Mr. Inslee, you voted against that. And then I look at this and say, if you are so concerned with regard to protecting and maintaining institutional and physical infrastructure to promote the deployment of sustainable biomass, how could you have voted against what Mr. Walden was doing.
Let me ask.
That has nothing to do with Enron. It has nothing to do with Bush tax cuts.
Would you like me to answer your question?
Please.
When I go to the Wenatchee National Forest, as I did last summer, places I've been going since I was 6 years old, there are thousands of acres of dead and dying trees because of a budworm. And it's caused by climate change because now the winters aren't cold enough. They are not cold enough to kill the beetles that are killing our trees. Now, one of the reasons I'm voting against some of your amendments is I believe that they will not be of assistance to stop the thing that's killing the forest that both you and I love. That's a reason. May not be good enough, but I hope we can pass this little amendment that apparently we both agree on. Thank you.
Well, that was more helpful, Jay. Thank you.
Gentleman's time has expired. I'd like to now proceed to a vote.
Mr. Chairman.
Yes.
Mr. Chairman, I have a quick question for council, if I might, please.
Let me just ask, how many members wish to speak on this amendment? 1, 2, 3. If I would like to request that we limit the time to 3 minutes each. Without objection, that'll be the order.
No, I'm reserving the right to object. In fact, I object. I don't know.
Okay. Mr.
I'm coming
Fields
into this.
recognized. You willing to accept 3 minutes?
Yes.
Thank you.
Thank you. Council, I'd like to go back to the Schakowsky amendment, back to the section 3 under duties, starting at line 17 on page 1, going through the bottom of page 2, line 11. My first question is, it talks about complaints being brought on behalf of energy customers on matters concerning rates and services of public utilities and natural gas companies. Are those currently subjects of litigation in federal court under current law?
Under current law, in both the Natural Gas Act and the Federal Power Act, there are special provisions for complaints to be brought by consumers alleging that a natural gas company or a public utilities rates are unjust and unreasonable, and the Commission will then entertain such complaints. This provision would give this Consumer Advocacy Office the same power as other representatives before FERC on that matter.
Specifically looking at subparagraph I, it gives them the right for judicial proceedings in the courts of the United States. Do they currently have the right to bring those complaints in judicial proceedings of the United States?
This gives me an opportunity to correct my prior answer in terms of which is Clause 3, but it applies to Clause I-2. The only instance in which this Consumer Advocacy Office would appear in a judicial proceeding in the Court of the United States is under the subparagraph A language that restricts that to being on matters concerning rates or service of public utilities and natural gas companies under the jurisdiction of the Commission. So to the extent that this consumer office participated at the Commission in a regulatory proceeding regarding a natural gas company or a public utility, and that decision was appealed to court, as frequently happens, the consumer office would be able to participate in the appeal as well. But it is restricted in the courts and in the other federal agencies and commissions to those matters that are related to the rates and service of the utilities under the FERC jurisdiction. So it is limited. It would not bring a complaint directly in a federal court, but if there were a complaint proceeding at FERC that were appealed, it could continue to participate. It would not have to drop off.
So we're not creating a new federal cause of action?
No.
Only a question of who can act on behalf of whom?
This would allow this office to act on behalf of consumers through the entire process at FERC and beyond an appeal.
And you're saying the judicial proceedings would only be an appeal, in effect, of the initial rulemaking powers or the initial proceedings before the Commission?
This language clearly limits this office to appearing in federal court only when it concerns rates or service of public utilities and natural gas companies under the jurisdiction of the Commission.
Thank you.
Ms. Blackburn, are you willing to take 3 minutes, or do you want your whole 5?
Mr. Chairman, my question was specifically about the
No, I want to recognize you. How much time do you want me to recognize you
I
for?
can go with even less than the 3 minutes. Thank you.
Okay, I'll recognize you for 3 minutes, and if you give back some, that's okay, too.
Thank you. I appreciate that. My question dealt with the judicial proceedings and the clarification that Mr. Deal was just seeking, and I appreciate having that. I think the only other question I would have for counsel is going down to line 17 of page 2, C, where it says investigate independently without duplicating any commission investigation or within the context of formal proceedings, the services provided by, the rates charged by, and the valuation. So my concern would be, and my question would be, under this, and with the, could they instigate an investigation and then on behalf of a ratepayer and then carry that investigation into a court and represent them from your reading from this?
My reading of the language is they could initiate a separate investigation of the services provided by, the rates charged by the companies that FERC regulates.
Okay. And then carry that into a court.
They could investigate.
Okay. All right. Thank you. Yield back.
Mr. Walden, to close the debate, I recognize you for 5 minutes.
Thank you very much, Mr. Chairman. I want to speak in opposition to the Inslee Amendment, and I do so because of, in part, the issues raised by my colleague, Mr. Booyer. And I want to raise here, perhaps somebody, Nathan, if you want to hold this up. This is an example of what we're talking about. This is an overstock stand. It's in Northern California, and it's a stand that needs to be reduced in terms of the mass there to deal with fire risk. That's one strategy for adapting to a drier, warmer climate. Now, this photo was taken before the thinning took place. Now, let's go to the next one, please. This is what they're trying to get to and manage to. This is an old-growth stand. All right? This is to adapt to climate change. This is, according to the Pacific Northwest Research Station, their science update on how you adapt forest management. Now, part of the argument I'm making, we can put that one down, this is what they're trying to manage. You open up the stand, it allows the old-growth trees to become healthier, survive bug infestation because they're not stressed. Indeed, if you've got climate change, you have warmer temperatures, drier climate, more drought, more risk. My argument of my amendment, and I'll continue to offer various versions of it in the days and nights ahead, is that material that they took out to get this stand in balance should count as renewable energy if it's put in some sort of device that either turns it into a brick like this or a puck or is burned as pellets to heat a school like they're doing, well, actually a hospital in Burns and a school in Enterprise. Now let's go to the last one here. This is what you get when a fire goes through a forest. This is called a forest fire. And the debris that is left, this is out in Harney County, where, by the way, they have more than 20% unemployment right now. There is a company, perhaps represented in this room, that is interested in siting a biomass facility to take debris like this off the Malheur National Forest and burn it efficiently, cleanly. EPA's looked at all this. You can go find all the data on how they do this, and produce electricity. What holds them back? They can't get a guarantee of supply off the Malheur National Forest. Even though at the current rate of treatment, the Malheur National Forest will take 28 years to catch up with the overstock stands, kind of like the ones I showed you in the first picture. Now, I guess, with all due respect to my friend from Washington State, those folks don't need universities and others to go spend $5 million or whatever it is. They're ready to put people to work in a county that's got over 20% seasonally unadjusted unemployment. This county, by the way, is, if you lose your job in Burns, it's like driving from here to Philadelphia, from here to John Day to get a job. That's the nearest community. These are really rural areas, okay? Surrounded by national forests that we're the stewards of, and we're doing a crummy job of that stewardship. And then you put in law provisions that prevent these folks from taking the material that has to come out to get in balance to deal with climate change and put it in a modern, efficient, new technology, new energy device to produce electricity, to heat a hospital, and reduce their carbon emissions substantially because they're not using petroleum products now. All the things you say you want, you vote against. And we get high unemployment, and you get forest fires. And we don't get ahead of the problem. The Wenatchee Forest is full of bug infestation. By the way, the material that would come off of that as they thin and take it out, because that's a mature stand forest, won't qualify as renewable energy, won't qualify as a biofuel if they turn it into that. So you don't create the incentives, you don't create the jobs. That's why I'm passionate about this. Come walk in our shoes.
Gentleman, yield for a question?
Yes, certainly, sir.
So you will vote against Mr. Inslee's proposal to set up a national bioenergy partnership with 5 regions to try to bring the private sector and the government together.
Right.
Because he voted against your amendment?
No, that's not it, and reclaiming my time. I'll tell you why. I'll tell you why. Because the answer he proposes is to go borrow $5 million from somebody. We sure as God knows doesn't have it. You're going to have to go borrow it. It's going to be more to the debt. To create a whole new government and infrastructure system where, frankly, we've got the material. You've got the private sector ready to invest. They'll do the right thing for the forest, the ecology, the environment, the habitat, the jobs, reduce forest fires, do all the right things, create markets, and put people to work. And my time's expired.
We'll now proceed to a vote on the 2 amendments in block offered by Mr. Inslee and Ms. Schakowsky. And we'll go right to a roll call vote. All those in favor of the amendment will vote aye when their name is called, or those opposed will vote no.
Accepted those 2 and then
For both of them? Are these in block?
Mr. Waxman.
Aye.
Mr. Waxman votes aye. Mr. Dingle. Mr. Dingle votes aye. Mr. Markey. Mr. Markey votes aye. Mr. Boucher. Mr. Pallone. Mr. Pallone, aye. Mr. Gordon. Mr. Rush. Mr. Rush, aye. Ms. Eshoo. Ms. Eshoo, aye. Mr. Stupak. Mr. Stupak, aye. Mr. Inslee. I'm sorry, Mr. Engel. Mr. Engel, aye. Mr. Green. Mr. Green passes. Ms. DeGette. Ms. DeGette votes aye. Mrs. Capps. Mrs. Capps, aye. Mr. Doyle. Mr. Doyle, aye. Ms. Harmon. Ms. Harmon, aye. Ms. Schakowsky. Ms. Schakowsky, aye. Mr. Gonzalez. Mr. Gonzalez, aye. Mr. Inslee. Mr. Inslee, aye. Ms. Baldwin. Ms. Baldwin, aye. Mr. Ross. Mr. Weiner. Mr. Weiner, aye. Mr. Matheson. Mr. Butterfield. Mr. Butterfield, aye. Mr. Melanson. Mr. Barrow. Mr. Barrow votes aye. Mr. Hill. Mr. Hill votes aye. Ms. Matsui. Ms. Matsui, aye. Mrs. Christensen. Mrs. Christensen, aye. Ms. Castor.
Aye.
Ms. Castor votes aye. Mr. Sarbanes.
Aye.
Mr. Sarbanes, aye. Mr. Murphy of Connecticut. Mr. Murphy votes aye. Mr. Space. Mr. Space votes aye. Mr. McNerney. Mr. McNerney votes aye. Ms. Sutton. Ms. Sutton votes aye. Mr. Braley. Mr. Braley votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Barton. Mr. Barton, no. Mr. Hall. Mr. Hall votes no. Mr. Upton. Mr. Upton, no. Mr. Stearns? Mr. Stearns, no. Mr. Deal? Mr. Deal, no. Mr. Whitfield? Mr. Whitfield votes no. Mr. Shimkus? Mr. Shimkus, no. Mr. Shattuck? Mr. Shattuck, no. Mr. Blunt? Mr. Blunt, no. Mr. Boyer? Mr. Boyer, no. Mr. Radonovich? Mr. Pitts? Mr. Pitts votes. Mr. Pitts votes aye. Ms. Bonomack? Ms. Bonomack votes no. Mr. Walden? Mr. Walden, no. Mr. Terry? Mr. Terry, no. Mr. Rogers? Mr. Rogers, no. Mrs. Myrick? Mrs. Myrick, no. Mr. Sullivan? Mr. Sullivan, no. Mr. Murphy of Pennsylvania? Mr. Murphy, no. Mr. Burgess? Mr. Burgess, no. Ms. Blackburn? Ms. Blackburn, no. Mr. Gingrey? Mr. Gingrey, no. Mr. Scalise? Mr. Scalise, no. Mr. Matheson? Mr. Matheson votes aye. Mr. Green? Mr. Green, aye. Mr. Melanson? Mr. Melanson, aye. Mr. Ross? Mr. Ross, aye. Here.
There's Ms. Bonomack wishes to
I'm sorry.
respond to the roll.
Ms. Bonomack, off, no, and on, aye.
Have all members responded to the roll? Any member wish to change his or her vote? If not, the clerk will tally the vote. Bless you.
On that vote, Mr. Chairman, the yeas were 36 and the nays were 20.
36 ayes, 20 noes. The amendments are agreed to.